Let's dive into something really fascinating today. We're looking at the history of American law,
Hmm.
not as some dry collection of rules, but really as a living thing.
Yeah, something constantly evolving.
Exactly. It's been, hammered into shape by history, by culture, by just people's lives.
And the sources we're looking at today, excerpts from a major work, they really map out that evolution.
They do. So our mission here, for you listening, is to guide you through this incredible history. We want to pull out the surprising bits, the key insights.
The things that help explain how the American legal system, and really American society too, got to where it is now.
Yeah, how it all fits together.
We'll be touching on, well, quite a lot. Early courts, colonial customs,
The rise of lawyers, how law dealt with huge changes like industrialization.
changing families, civil rights struggles,
Yeah.
right into the 20th century. It's
Yeah.
a big sweep.
Okay, let's unpack this. First off, what's really clear from the sources is that American law didn't just, pop into existence.
No, definitely not. It started with deep roots in England. Transplanted, you could say.
But not just a simple copy-paste job.
Not at all. And one reason is that English law itself wasn't just one single thing.
Yeah.
You had the common law, sure, but alongside it, this really interesting mix of local customs.
Like that inheritance custom in Kent you mentioned.
Hmm?
Gavelkind.
Exactly, gavelkind.
Yeah.
Instead of the oldest son getting everything, primogeniture, all the sons inherited land equally.
It feels very different, much more maybe egalitarian in a way.
It does. And these kinds of local variations, they were actually pretty influential over here in early America. You see this blend right away.
This mix of English structures and local needs shaping things.
Precisely. Look at the early court systems, like the Massachusetts County Courts.
Okay.
They were incredibly powerful, and often it was just one single magistrate holding all of this power.
And not just judging cases, right?
Right.
It was broader than that.
Oh yeah, much broader. Handling marriages, making people work on public projects, dealing with vagrants.
The sources mention drunken Indians, even ordering the whipping of Quakers. It's quite a picture.
It really shows how localized and, well, personal justice and administration were back then.
Things got a bit more formal later, with the justice of the peace.
Yeah, towards the end of the 17th century, the JP role emerges. It looked more English, as the source says, but it was still operating in this colonial context that was becoming more secular, less overtly religious than the very first courts.
There's this interesting back and forth, isn't there? Between wanting things simple and the pull towards formality.
Definitely. Early Massachusetts Bay, they had this real kind of reform zeal.
What did that look like?
Well, they wanted inexpensive procedures. Summonses written in plain English, not jargon. Fewer complicated legal forms. Minimal costs.
Sounds pretty good for the average person.
It does. But the sources talk about a backsliding in the 18th century.
How so?
As you get a distinct legal profession emerging, lawyers bringing their knowledge of complex English procedures.
Things got more complicated again.
Yet, pleading became increasingly rigid. You could actually lose your case, not because you were wrong on the facts, but because of some technical mistake in the paperwork.
Like getting a name slightly wrong or something.
Exactly. So the rise of lawyers meant more sophistication, maybe, but also more barriers for people without legal help.
You see that adaptation pattern elsewhere too?
We do. Criminal, for instance. It could be incredibly harsh, like Dale's laws in early Virginia, really draconian.
Mm-hmm.
But generally, colonial practice started less formal than England's, though it did adopt more English procedures over time.
And what about business? Commerce must have been huge.
Absolutely central, especially since there wasn't much actual cash, hard currency floating around.
So people used IOUs and things?
Exactly. Commercial paper bills of exchange, promissory notes.
Mm.
And the court spent a lot of time enforcing these, especially handling debt cases.
Debt collection was a big part of their workload.
Huge. The justices of the peace courts were just swamped with debt cases.
And when we talk about law in daily life, we have to mention the poor laws.
Oh, absolutely.
Yeah.
Based on that English statute from 1601, 43 Elizabeth.
The core idea was local responsibility, right? Your town had to take care of you if you had settlement there.
Right, official residency. But this led to some really harsh practices.
Like warning out.
Yes, warning out. Towns were terrified of the cost of supporting poor newcomers.
So they'd just tell them, officially, we're not responsible for you.
Pretty much. Sometimes they warned out almost everyone who arrived. The sources mentioned over 6,700 people warned out in just Worcester County, Massachusetts, in about 50 years.
Wow, 6,700. In one county, that's a lot of people being told to move on.
It's staggering. And the rules for figuring out where someone's legal settlement actually was were incredibly technical.
There's that story about Obadiah Brown.
Yeah, it's heartbreaking. He lived and worked in Providence, Rhode Island for over 50 years. 50 years.
And then
Then he fell on hard times, needed help, and they legally shipped him back to the Massachusetts town where he was born because technically that's where his settlement still was.
after half a century somewhere else, that just seems wrong.
It highlights the rigidity of the system. But looking at these early trends overall, this mix of English law and local needs,
The swings between simplicity and formality.
and how deeply law was woven into daily life with debt, poverty, local order, it really sets the stage.
You can see the beginnings of a distinctly American approach, even while still under that English influence.
Exactly. It was law adapting to a new world right from the start.
Okay, so then comes the Revolution, big break with Britain. You'd think maybe they'd toss out all the English legal stuff.
Well, that's the fascinating paradox that the sources point out. They rejected British rule, the king, Parliament.
But not the common law itself.
No. They actually defended it fiercely, saw it as their birthright, the very foundation of their liberty.
Which is kind of ironic, defending the law of the people you just fought a war against.
It is. And practically speaking, they had to rely on English law books at first. There just weren't any American ones yet.
Yeah.
Almost no published American case reports, no homegrown legal textbooks. They used what they had.
Gotcha. And the new state constitutions drafted around this time, they tell a story too, don't they? They weren't all the same.
Not at all. They really reflect the different priorities and worries in each state.
Like what kind of things?
All sorts. Rules about religion and holding office, how the military should be set up, and some really specific bans.
Bans?
Yeah, Tennessee's 1796 Constitution said clergy shouldn't hold office, basically shouldn't be distracted from their main job,
Okay.
and the proposed state of Franklin. They apparently considered banning lawyers and doctors from office.
Huh. Banning lawyers and doctors? Wonder what the story was there. Says something about public opinion, maybe?
Could be. But they also tackled really practical stuff affecting ordinary people. Inheritance, for example.
How so?
Georgia's 1777 Constitution said estates should be divided equally among the children, and the widow got a child's share. A clear break from primogeniture.
And debt. That was still a big issue.
Huge.
Yeah.
North Carolina moved really early, 1776, to limit imprisonment for debt, at least where there wasn't fraud involved.
It's interesting what they chose to put in their foundational documents, these very specific things.
It really shows these constitutions weren't just abstract philosophy. They were dealing with immediate concerns about fairness, money, and who should have power.
We also see a shift on the bench starting around then, right? From lay judges to professional.
Yeah, a slow but steady shift. Lay judges, people without formal legal training, were super common, especially in lower courts out west, down south.
For a lot of people, that was the face of justice.
Absolutely, even if later writers sometimes made fun of them. But in the higher courts, lawyers gradually took over.
Like in Vermont.
Yeah, the source mentions Vermont Supreme Court in 1787. Only one lawyer, Nathaniel Chipman, among the 5 judges. The rest were laymen.
So why the change? Was it just law getting too complicated?
That was a big part of it, I think. As business law, property rules, court procedures got more intricate, you really needed that formal training.
Makes sense.
But it raises that question again. What do you gain with professionalism and expertise? Consistency, maybe. And what do you lose? That connection to local, non-expert understanding.
And how judges actually ran trials changed too.
Drastically, according to the sources. Early on, judges had a lot more freedom in instructing juries.
How?
They could summarize the evidence,
Yeah.
comment on witnesses, explain the law in really plain language.
Like that Delaware Chief Justice Bassett.
Yes, explaining adverse possession. Basically, getting ownership by occupying land for a long time.
Yeah.
He told the jury, if you hold a corner for 20 years, you can just snap your fingers at me.
Ha! Very clear. Very memorable.
Totally. Compare that to what jury instructions often became later.
Yeah.
These dry, dreary, stereotyped, abstract rules written in careful lawyer talk.
Almost like reading from a script.
Pretty much.
Yeah.
Sometimes just copied from form books. And states even passed laws saying judges couldn't comment on the evidence anymore. That was strictly for the jury.
So, no more judicial finger snapping.
Not in the official instructions, anyway. And think about the country expanding westward. New territories needed laws fast,
How did they manage that?
often by just borrowing. The adopt and publish method.
Meaning?
They'd essentially copy blocks of statutes from older established states.
Like Michigan taking Virginia's law about adopting the common law?
Exactly. It was efficient, a pragmatic way to get a legal framework up and running quickly, even if it was a bit of a patchwork quilt.
A very American approach, perhaps? Adapt and make do?
It definitely highlights that practical, adaptive streak in building the nation's legal systems.
Okay, moving into the 19th century. Things really start to speed up, don't they? Massive changes.
Huge changes. Industrialization, big economic shifts, growing inequality, and law is right in the thick of it all.
Now, the common idea is pure laissez-faire in the 19th century. Government hands off the economy. But the sources suggest it was more complicated.
Much more complicated. States were actually very active partners with corporations, granting charters for big infrastructure projects, canals, railroads. The sources call it an orgy of chartering.
An orgy of chartering. Love that phrase.
And you see clear evidence of lobbying. Different business groups pushing state legislatures for laws that helped them. Ohio, during the canal building era, is a key example.
So the state was definitely involved, shaping the economy.
Absolutely. And commercial law itself had to expand rapidly to keep up.
Contract law changed.
Yeah, it evolved. For instance, courts started recognizing that a third party, someone not originally part of the contract, could sometimes sue to enforce it if the contract was made for their benefit. The New York case Lawrence v. Fox is the classic example.
And rules about damages, like when a contract is broken.
Those developed too, influenced by English cases like Hadley v. Baxendale. The focus shifted towards damages that were the natural consequences of the breach,
Trying to make things predictable.
sort of reflecting this idea of an impersonal, frictionless market, as the source puts it. Predictability was key for business.
But this industrial boom had a dark side. Accidents.
A terrible dark side. The sources call industrial accident law a bloated monster. The number of injuries, especially on the railroads, was just horrific.
And the law often protected the companies, didn't it? The fellow servant rule.
Yes, initially. That rule made it extremely difficult for a worker injured by a coworker's carelessness to sue the employer. The idea was basically you knew the risks of working with others.
Which seems incredibly unfair from today's perspective.
Deeply unfair.
Yeah.
And the whole system was wildly inefficient. So much money went to lawyers and insurance adjusters, not the injured workers.
Did things start to change?
Slowly. States began passing laws to modify or abolish the fellow servant rule, especially for railroad workers, starting with Georgia in the 1850s.
This whole area, accident law, it really shows the tension of the times, doesn't it?
It really does. You see debates about things like strict liability. Should a company be liable for harm from dangerous activities, even if they weren't negligent?
Like the English case Rylands v. Fletcher.
Exactly. But then you had judges like Judge Doe in New Hampshire fiercely attacking that idea.
Why?
He argued it would stifle progress, put a clog on industry, send society back to barbarism.
Wow. So protecting industry was seen as vital for progress, even if workers paid the price.
That was a powerful argument. Balancing growth and worker safety was, and still is, a core tension.
Property law was changing too, aimed at making land easier to buy and sell.
Yeah, trying to get rid of some of the old, complicated English rules about land ownership, things like entails that kept land locked up in families for generations, untying those knots for a country with so much land.
But the rules for public land, government land, were kind of a mess.
A complete mess, according to the sources, a hopeless and inconsistent jumble.
How so?
Policies offering free land right alongside policies selling land. Huge grants to railroads, colleges. It basically created a field day for speculators.
Who snapped up all the best bits?
Pretty much. The sources mention ads from the 1870s for millions of acres for sale in Kansas by railroads and land companies. It was a frenzy.
But eventually people started realizing resources weren't infinite.
Right. Towards the end of the century, that boundless optimism starts to crack. You see the beginnings of the conservation movement.
Yellowstone.
Yellowstone National Park, created in 1872, then giving the president power to create forest reserves, a recognition that maybe we can't just exploit everything forever.
Another interesting development was the Spendthrift Trust. What was that about?
Protecting family wealth, basically. Dynastic wealth.
How did it work?
It allowed wealthy families to put property in trust for their heirs in a way that creditors couldn't get at it. So
Yeah.
if your son was reckless with money, his creditors couldn't seize the family fortune held in the trust.
Shielding wealth from bad luck or bad decisions.
Exactly. The famous legal scholar John Chipman Gray hated it. He called it paternalism, even wrongly linked it to socialism. but it was really about preserving elite family fortunes.
And at the other end of the spectrum, the poorhouse. The sources paint a grim picture there, too.
Yeah, they challenged the official view. Officials often talked about the unworthy poor, people who deserve their fate.
But the reality.
The reality, according to the source material, was that poorhouses were filled with the detritus of capitalism. People hit by economic slumps, illness, old age, accidents, mostly vulnerable working-class folks.
A stark contrast to the protected wealth in spendthrift trusts.
A very stark contrast. It shows how the economic system created winners and losers, and the law often reflected or even reinforced those divisions.
Law enforcement started to professionalize around this time, too. City police forces.
Yeah, mid-19th century, Boston 1838, New York 1845, trying to copy London's model, though imperfectly. But this was mainly a city thing. Rural areas lagged way behind.
And the lawyers themselves, they started organizing.
They did. Bar associations started popping up, sometimes with goals of reform or cracking down on unqualified people practicing law.
But also social clubs.
Oh, yeah. Dinners, lectures, punch bowls. And crucially, they started setting rules. Rules about fees and especially rules against advertising.
Which helped the established lawyers more than the small guys.
Definitely. It made it hard for the storefront lawyers serving ordinary folks to get clients, while the big firms relied on their established networks and connections. It limited competition.
Okay, let's shift into the 20th century. Another period of huge change, technology, social movements. How did law keep up?
Well, the legal profession itself continued to change dramatically. One huge shift was the rise of law schools.
Becoming the main way to become a lawyer instead of apprenticeship.
Exactly. Law schools sold themselves as being more systematic, more scientific. You had Dean Langdell at Harvard pushing the case method.
Studying appellate court opinions as the core of legal education.
Right. Viewing law as a science you could derive from these cases. The critics argued it was too abstract, too removed from the messy reality of how law actually worked for people. A geology without rocks, one critic called it.
And the kind of jobs lawyers did change too, more working for companies.
Yeah, you see the growth of the salaried lawyer. Lawyers who weren't partners in a firm but employees. Or house counsel, working directly inside a corporation.
Like for the railroads.
Being general counsel for a big railroad became a really prestigious, well-paid job after the Civil War. A big shift from the old model of the independent, maybe even traveling lawyer.
Though that image lingered, the frontier lawyer.
Oh, sure. The sources mentioned the romance of the circuit rider, especially in less settled areas, lived on for a while.
Figures like Stephen Field.
Right. David Dudley Field's younger brother. Went west to California, apparently held court behind a dry goods box, speculated in land.
And ended up on the U.S. Supreme Court.
Exactly. Embodies that mix of frontier grit and legal ambition.
But the 20th century also forces law to grapple with fundamental social issues in new ways. Race relations, for instance. The early part of the century sounds grim.
It was a real low point, according to these sources. Widespread lynching, segregation deeply entrenched by law, Jim Crow.
And the Ku Klux Klan had a resurgence.
Yeah, in the 1920s. Fueled by racism, but also intense anti-Catholic feelings. The sources even mention a Klan coin with hateful anti-Catholic doggerel on it.
So, with state governments often enforcing segregation, where could Black Americans turn?
Increasingly, they turned to the federal courts. The NAACP led the charge, using litigation because political avenues were often blocked.
Did they have success early on?
Some significant legal victories, yes. The Supreme Court struck down the grandfather clause used to deny voting rights in 1915.
And housing segregation.
In 1917, the court case Buchanan v. Worley struck down a Louisville city ordinance that mandated residential segregation by race.
But these court wins didn't immediately change things on the ground.
The sources are pretty clear. These were important symbolic victories, but they had limited immediate impact against deeply ingrained segregation and things like restrictive covenants in deeds. Progress was slow and hard-fought.
Law was also heavily involved in controlling sexuality.
Very much so. Sodomy laws were harsh, often targeting gay men. Police actively enforced them, sometimes through entrapment in places like public restrooms.
And federal policy?
Banned homosexuals from government jobs, from the military. It was pervasive.
But resistance grew. A gay rights movement.
Yes, paralleling the civil rights movement in some ways. As society gradually became more open and gay communities more visible, the legal fight back began, pushing for decriminalization, challenging discriminatory laws in court.
It was a long struggle, wasn't it?
Decades long. leading eventually to major Supreme Court battles like Bowers v. Hardwick in '86, which upheld a Georgia sodomy law,
A real setback.
a major setback. But then finally, in 2003, Lawrence v. Texas overruled Bowers, striking down the remaining state sodomy laws. A real landmark, showing how social movements can drive legal change over time.
What about family law? Common law marriage started to disappear.
Yeah, its decline really accelerated in the 20th century. The idea that you could be legally married just by living together and telling people you were married.
It didn't fit the modern bureaucratic world.
Exactly. It became an anomaly in an age that wanted official records, marriage licenses, certificates.
And there was a darker side to the push against it early on, eugenics.
Disturbingly, yes. The sources link some of the early 20th century opposition to common law marriage to the eugenics movement.
How so?
The desire to control who got married, based on ideas of sound policy, which really meant preventing people deemed inferior or unfit from marrying and having children. A chilling connection between law and discriminatory pseudoscience.
Wow. And divorce. Laws were strict, but rates went up anyway.
That's the paradox.
Yeah.
Divorce laws often required proving serious fault, adultery, cruelty, yet divorce became much more common.
So people lied.
It led to widespread formal charades, as the source calls it. Couples and lawyers basically engaging in pious perjury to meet the legal grounds, even if the reality was just incompatibility. A huge gap between the law in the books and social reality.
And criminal justice, the death penalty.
The rate of executions actually declined over much of the 20th century,
Why was that?
changing public attitudes, viewing executions as brutal, maybe barbaric, and growing awareness, especially through NAACP efforts, of racial bias in who got sentenced to death.
The NAACP was involved there too.
Heavily involved. Their litigation strategy was key, building up challenges that led directly to the massive Supreme Court decision Furman v. Georgia in 1972.
What did Furman do?
It found that state death penalty laws, as they were currently being applied, were arbitrary and capricious, and therefore unconstitutional under the Eighth Amendment.
So it stopped executions.
It effectively created a nationwide moratorium for several years, forcing states to completely rewrite their death penalty laws if they wanted to reinstate it. A huge moment.
Lastly, the sources mention government itself becoming more fragmented.
Yeah, described as a patchwork, a rug made of rags.
Meaning?
Just the sheer number of overlapping government bodies, federal, state, county, city, plus countless special districts, school districts, water districts, sewer districts, even mosquito abatement districts.
A reflection of modern complexity.
Exactly. The intricate, layered nature of governing a large, diverse country in the modern era.
So if you pull all these 20th century threads together,
You really see law responding to and being shaped by these massive societal shifts, technology, social movements, changing values.
law as both a tool of control.
Definitely. Enforcing segregation, policing sexuality, influenced by bad ideas like eugenics.
But also a tool for change.
Critically, yes. A tool for challenging inequality, demanding rights. The NAACP's legal battles, the gay rights movement's use of the courts. It becomes this arena, this battleground, where competing visions of society clash.
It's really quite a journey when you trace it like that, from those early colonial adaptations of English law.
Through building a new republic's legal structures,
Yeah.
wrestling with industrialization's impact.
And then confronting all the social and technological upheavals of the 20th century.
And certain themes keep echoing through the sources, don't they? That tension between local control and central authority.
Yeah, and the gap that often exists between the formal law and how people actually live their lives.
Law's role in reflecting social change, but sometimes driving it too.
The way the legal profession itself changed became more institutionalized.
And just the constant need for the law to adapt, to respond to new realities.
And for you listening, all these historical layers, these developments, they're not just history. They've shaped the legal system you encounter today.
Absolutely. Your property rights, your civil liberties, how courts work, the role lawyers play, it's all deeply rooted in this history we've been exploring.
So maybe a final thought to leave you with, drawing from the sources. Think about those historical tensions we discussed.
Tradition versus reform. Formal rules versus messy reality. Central power versus local ways. Law's relationship with economic forces or social movements.
How do you see those tensions playing out in American law today? What part of this deep dive really stood out to you, made you want to dig deeper?
A great question to ponder.
Indeed. Well, thank you so much for joining us on this deep dive into the fascinating history of American law.